Do you know what a non-party witness deposition is? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. First of all, a deposition is a question and answer session given under oath. It's pretrial testimony. It's also known as an examination before trial. Now, what's a non-party witness? A non-party witness is someone who is not part of the lawsuit. He is not the person who is bringing the lawsuit, and he's not the person who's being sued either. Instead, he might be a witness to some of the events that occurred, and he might have useful information that could either help or hurt one side or the other. There are key reasons why you would want to question a non-party witness at a deposition. So here's the scenario. So let's say it's a car accident case and there was a witness at the scene, at the corner waiting to cross, and he saw everything. And in addition to getting his written statement about what actually occurred, now one side or the other wants to take that witness's testimony to find out truly exactly what happened. What did the witness see? What was he doing? What was his purpose of being there? Did he have an interest in recording this information? Why was he there? And why did he remember all this stuff? So now one or the other attorney has an opportunity to go ahead and conduct what's known as a non-party witness deposition. And all that fancy legal term means is that now we have an opportunity to question this person. They swear to tell the truth, and now the questions and the answers that he gives are going to be recorded by a court stenographer and then later put into a booklet known as a transcript. This way it preserves this witness's testimony, so now a year or two later when we go to trial, and now if this witness comes in to testify, if he says something different than what he has testified to in the pre-trial question and answer session, now that booklet can be used to cross-examine him and used to contradict his testimony. On the other hand, if that witness is no longer available or cannot come into trial, we can still use that information, that testimony that he gave, and then we can actually read that part of the testimony that he gave in the pre-trial question and answer session to the jury as part of the evidence in the case. And you can only do that when both sides have had an opportunity to be present and question the witness and ask them any follow-up questions. So why do I share this great information with you? I share it with you just to give you an insight and an understanding to what goes on in the litigation process in an accident case or in a medical malpractice case or even in a wrongful death case. We see this all the time. You know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, again, if your matter happened here in the state of New York and you do have legal questions, pick up the phone and call me. You know, I'd love to talk to you and answer your legal questions because this is what I do every single day. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.